Good morning, everybody. You are aware, I have started this web series to bring to the notice of the listeners all the conflicting constitutional content whereby the constitution is distorted and the people are ditched, swirling in poverty, engaged in conflicts of caste, community, creed, region, religion, language, and sex. However, taking digression from here and there, I have also been commenting on contemporary conflicting issues. In one of my previous videos, two videos of course, I have discussed about reservations in government employment. As regards the regular discussions are concerned, we have completed up to Article 174. We dealt Article 172, 173 and 174 in one video. To recapitulate, Article 172 was definition of state legislatures, which includes the legislative assembly, the legislative council, if there is one, and the governor of that state. So, governor is part of state legislatures. He being the representative of His Excellency, the President of India, is the only elected executive in India under Article 55, read with Article 328. Article 73 was about qualification of legislators. MLAs have to be of 25 years of age at least. It is 30 years for MLCs, and we know it is 35 years for the governors and the President of India. Article 174 is about the powers of the governor to adjourn the house and to dissolve the house. Article 175 reads the right of the governor to address the legislatures. The governor may address the legislative assembly or the legislative council. That is the right of the governor. Please remember the word right. And Article 176 reads the governor summons the legislative houses to assemble, and however 6 months shall not elapse between two sittings. So the governor shall address each house or both houses assembled together at the commencement of each session. So at the commencement of each session, governor has to address the legislatures. This was of course changed through first amendment to the constitution, that the first session of the year, instead of each session, only the first session of the year may be addressed. The governor shall inform the members the reasons for their summoning. Under Article 175 Clause 2, the governor may send messages to each of the houses, and they shall have to discuss with convenient dispatch the messages sent by the governor. And Article 176 Clause 2 says that a specified time shall be allotted for discussion on the messages sent by the governor. Apparently, there appears no conflict or controversy in it, but in practice, there is a lot. We have seen in Telangana, the governor was not invited to address the legislatures. There was always a tussle between the chief minister and the governor. It is a funny thing for me. In fact, ministers and the governor should belong to one political party, that is the political party of the President of India, because state ministers are appointed by the governor under Article 164 and removed at his pleasure, and the chief minister has to report all administrative and legislative proposals to the governor and provide such of the information which the government may seek. The job of state ministers under Article 163 shall be to aid and advise the governor in discharging his functions. The minister shall not be entitled to advise the governor in matters which require his own discretion. That means governor is much more superior and executive power of the state. Ministers are his appointed subordinates. Unfortunately, we are treating the person who has majority in the assembly as chief minister. This is just contradictory to the constitution. And the governor was lamenting, felt insulted. The legislators or the chief minister supporters comment, the governor is at fault. The governor need not be invited. saying that we are elected people, the governor is not elected. But please remember, you are elected as legislators, not as executive. As executives, as minister, the posts come by appointment by the governor, not by majority in the legislatures. In fact, the governor or his council of ministers should not have majority in the legislative assemblies or the legislative councils, rather legislatures of the states. If they have majority, they can pass draconian laws. They can pass on all social, political, economic benefits to their henchmen. They may oppress the opposition parties. They may resort to retribution against opposition party workers. They will loot the resources of the state. This is not democracy, and such a system is not contemplated under Indian Constitution. Under Indian Constitution, President of India is elected by the Electoral College consisting of all the MLAs and members of both houses of the Parliament under Article 55, and he has to form his government under Article 74 and 75 at the union level, and his deputies, his nominated governors should form governments in the states under Article 163 and 164. That is an umbrella model. If they do not have majority in the legislatures, that is supposed to be the best democracy as obtaining in the United States of America. In America, the president does not command majority in the Congress, and the governors do not command majority in the state assemblies. That is the most ideal democracy. The ruler should not have majority. If he has majority, his word will become law, and that will smack of a monarchy, not monarchy, a dictatorship. The governor was lamenting that she was not invited to address the legislatures. We have seen in Article 175, the heading itself is that the right of the governor to address. In Article 176, we have seen the governor shall summon. So who should invite whom? The legislatures may invite formally the governor, but the governor shall not invite. The governor will summon both houses and address them and sends messages to the legislatures which are supposed to be conveniently dealt with in the legislatures, which of course is not understood by Indian polity, press and judiciary and intelligentsia of this country, as a result of which we are going in a wrong direction, anti-constitutional direction. We have seen in Tamil Nadu, there was a tussle between the chief minister and the governor, and ultimately somebody representing the majority in the legislatures or maybe any government official as petitioner has filed a petition in the Honorable Supreme Court that was titled as Government of Tamil Nadu versus Union of India. Such a blunder, legal blunder. The state of Tamil Nadu must be represented by the governor or any of his assigns, not somebody else, and not especially against him. And when it is said versus Union of India is represented by the President of India or his assigns. So in result, this cause title of State of Tamil Nadu versus Union of India is termed as Governor of Tamil Nadu versus President of India. You see how funny is this? Unfortunately, the Honorable Supreme Court has said in that case that the governor is bound to assent or return the bills within 3 months. Unless he does that, the bills are deemed assented and further assent is not necessary and they become law. Such a great transgression of constitution and democracy. In a democracy, there should be a separation of powers between legislatures and the executive. If you say the executive is secretary to the legislative party leader, where is separation of powers? How it can be democracy? The worst is it is a dictatorship. This way, India was totally destroyed. Constitution was distorted. Yet again, another story we have seen in West Bengal. The then governor Jagdeep Dhankar, who later became Vice President of India, wanted to visit right-turn areas and he was not allowed by the Chief Minister to move from his Raj Bhavan. It is as good as the servants kidnapping their master in his palace and misrule the country. In Telangana also it happened. The Chief Minister has flown to a temple, Bhadrachalam, by helicopter, whereas the governor of that state was refused facility of helicopter and she had to go by train. In fact, in accordance with the Constitution, the Chief Minister cannot sit before the Governor without being asked to do so. Otherwise, he will lose his job. I told you several times under Article 164, the terms of office of ministers shall be during the pleasure of the Governor. An unquestionable authority to appoint and remove ministers, including Chief Minister. Yesterday or the day before, I was going through a news item, a newspaper, that Governor's office has requested the visiting Tirumala Devasthanam chairman to consider recommendation letters from the Governor's office also. That is the bad state of affairs in India. A governor is supposed to be like a king of the state. All others are his servants. And especially employees are his servants under Article 310, not of the Chief Minister. Unfortunately, the reverse things are happening. That is the cause of this political unrest, political instability, political uncertainty, political immorality, social strife, and backwardness. I request you to kindly ponder over the matters presented to you, and I request you to please subscribe, share, and comment on my videos, and I will be glad to reply to your worthy comments. My purpose of starting this web series is to bring to the notice of the listeners all the constitutional conflicting issues which resulted in all this political instability, poverty, etc. Thank you. Thank you for watching my videos. Thank you.